You did it. Really. Not enough.
No, you don't, but I'm telling you.
So,
Maybe approach her.
Do you want to visit?
we're not back in.
Wrapped up in brown paper. And yes, here's the original bag. It says number 7 knit shirt. This is trial exhibit 10. B and C, the brown shoes that were reflected in the photograph, and the bag is well torn. These are the sweatpants marked biohazard. Bag is not resealed. Yes, says number 32 gray sweatpants, number 33 purple sweat shirt holder. I don't know. But it's evident on that, Your Honor, that the pants, the sweatpants are well stained, appears to be blood. believe they were the pants that Ms. Peterson was found in at the time that the police and the EMT arrived. Your Honor, these are the white Converse sneakers. Bags open, marked biohazard on the opposite side of the bag, and introduced in evidence in trial as Exhibit 3-1, I believe. This is another pair of socks, Your Honor. It was marked during trial as State's Exhibit 9A. They're open. The exhibit that went with seems to be a Polar-Tech shirt, so it may have been the top of the sweatpants. We were having trouble reading. In an unmarked bag. And Your Honor, this is similar to the manner in which we found the items in the box at the time it was viewed. I think it's better packed now. I don't know if Mr. Dornfried would agree with me. I think there was more touching of the different exhibits, but it's obvious that nothing was protected from touching anything else. And I think it verifies Mr. Hendrick's testimony. And so that is what we needed to show the court today and wanted to show the court.
All right.
Thank you, Your Honor.
Other questions, Your Honor, nor I will not be utilizing any of the evidence.
All right. What's next?
Your Honor, there were two other pending motions that were filed with the court that I understood were going to be heard today. If I may refer to them. They're requesting various pieces of correspondence. The first was a motion to compel discovery related to any and all undisclosed notes, documents, emails, and or any other communications generated by law enforcement related to Michael Ivor Peterson.
Your Honor, before we get to the arguments, our forensic supervisor has a doctor's appointment and she has to leave in about 15, 20 minutes, and I don't know how long these arguments are going to take. But if we do need her assistance in putting these items back in the boxes, I would ask that she be allowed to do so at this time. I don't believe that whatever the defense has had opportunity to display these items to the court, and we'd ask that she's been here since 10 o'clock, that she has a doctor's appointment, and that she be allowed
That's
to
fine.
leave.
That's fine.
If we can get that packaged up before she leaves.
That's fine.
Okay. Everyone is.
We had our first test, first case with DNA.
Your Honor, I believe the motion that defense counsel was referencing dealt with the notes, documents, emails, and other communications generated by law enforcement related to Michael Ivor Peterson. Your Honor, within the motion was referenced as Brady, which deals with evidence favorable to the defense as well as deals with impeachment. Also, we're dealing with 15501 subsection 6 that deals with making available to the state, that being law enforcement, on a timely basis all materials, information acquired in the course of all felony investigations. And then also we have the discovery under 15A-903, which addresses the disclosure of the state's files. And Your Honor, this case is unlike perhaps any other case that we've had here in Durham, because not only are we dealing with the open file, but as a result of the prior motion for appropriate relief, in addition to having the open file, the complete file, which the files don't mean anything, don't mean generally anything that deals with an individual, but rather all of the information that is obtained during an investigation of offenses, that being information generated from that investigation. The defense has also had a glimpse into the minds of the prosecutors, because as a result of the motion for appropriate relief, all of the notes for the prosecutors, the work product, had to have been turned over. When we look at what is being asked for, though it's being asked for in there's three different things that are being asked for, what essentially, if we combine them, is emails, documents, recordings relating to the defendant and his criticism of or relationship with the police department, the DA's office, or any other law enforcement agency involved in these matters from July 1st of 1997 until the present. Your Honor, any communications that occurred prior to the death of Kathleen Peterson certainly could not have resulted from the investigation. There's no indication and there's no allegations relating to anything specific, relating to items that would be favorable to the defense, that are being referenced within these motions. In fact, when we go through the motion, although there is, they reference many articles that have been published, what they do reference as far as any emails dealt with an email by then Chief Chambers, who brought to the attention of the defendant that he was giving misleading information by using outdated information in his article. Your Honor, anything that happened prior to Kathleen Peterson's death would not be a result of the investigation, and also there's nothing to indicate that this would be Brady material. And therefore, Your Honor, the state should not be going on a fishing expedition, because that's what it is, to gather an email from any law enforcement, from any agency that had anything to do with this. So we're dealing with SBI, the State Crime Lab, the Police Department, or the DA's office, when there's already been open file discovery, as well as the notes leading to the thought process of the DA's office. Your Honor, is the same, I would contend, is the same that deals with any emails, and I'm not saying that they exist, I don't know, because what they're asking us to do is to go on a fishing expedition, and that is not what is contemplated. When we're dealing with Brady, we dealt with a situation where they knew of information related to a co-defendant's statement that was not turned over. When we're talking about open file, these are matters that are part of the investigation, and what is being referenced here could be an email from someone who has absolutely nothing to do with the investigation, just happens to be a police officer or a member of the DA's office or any other law enforcement agency involved. This request goes far beyond that which is contemplated by the 15A903 or by Brady, and therefore, Your Honor, since there is absolutely no indication of any type of material information that would be exculpatory or helpful to the defense as far as favorable in the sense of assisting him in his innocence, that therefore, Your Honor, that I would ask the court to deny the motion to compel as it relates to notes, documents, and emails, as the offense has already been given the open file, as well as basically work product up until the time of the conviction being overturned.
Well, Mr. Dornfree, did we even have emails in 1997? Did we have computers in 1997?
I think we did, Judge, because I remember in college, I had to borrow somebody's, but as far as email, I don't know.
Well, I do my jury instructions by computer, but in 1997, I was writing them out by hand.
I think when I was using the computer, I was using a typewriter. But,
All right, well, let's see.
so I would ask the court to deny that request.
Let's see what Ms. Darrow wants here.
Thank you, Your Honor. Well, we know that by 1997, that Chief Chambers and my client were sending emails to, each other, and the focus in part of the motion relates to July 1, 1997 through December 20th, 2001. And I know that by 2001, people were using emails quite consistently. We're not asking for a fishing expedition. What we're saying is that our client and the Durham Police Department had a somewhat contentious relationship, that as a result of that relationship, when Mrs. Peterson was found dead, the sole thrust of the investigation was geared toward Mr. Peterson. So we are seeking documentation that may exist regarding that. I would like to say easily that it probably doesn't exist. And yet, we just recently had a situation in Wake County where an assistant DA was using her personal email and controlling the prosecution or delaying the prosecution of an alleged victim in a case that she was going to trial on. And so whether or not those emails exist is very difficult to locate from the defense side. And I believe that a quick search of the computers with just the name Michael Peterson at the police department or other places may well show what, if any, correspondence there was between that time period prior to the death of Mrs. Peterson. So I don't think we're asking for too much.
Well, I think that DA, though, was presently in her position.
Pardon me?
She was presently in her position as DA. I'm not sure where the computer that Chambers would have operated is. I don't even know, probably doesn't even exist, Mr. Dondry. Why would they have a computer that old? Nobody has a computer that old. Well, except us.
Your Honor, I think if that turns out to be the answer, then that's the answer. But I don't think it hurts to instruct the prosecution to do a search, to ask the police department and law enforcement related to this case, for instance, the SBI as well, to just do a search. Were there any emails? Were there any communications between 1997 and 2001? I don't think we're asking for too much here.
The state would disagree, Your Honor, and when we're dealing with state agencies, there is another matter for which any individual can request emails that are on file, and that's through a request as relates to public documents. And that can be done, Your Honor, by the defense. They have access to that. I would contend that this goes beyond what was contemplated by the open file and investigative files, and there's been no indication of any evidence that, as counsel indicated, they don't have any indication that any of these emails exist. But that, and therefore, Your Honor, that's exactly what a fishing expedition is. And therefore, Your Honor, we would object.
And I would submit, Your Honor, that a public documents request would not disclose what we're looking for, because emails, I don't believe, are treated as public documents yet. I may be wrong, but I don't believe that when a person files a public documents request that they are granted access to all emails that may or may not have been sent or received in regard to the person or the topic they're seeking information on.
I don't believe those emails, if they existed, I don't believe they exist.
I believe there could be a search done.
But why would they keep the emails?
I am not technically savvy, Your Honor, but my understanding is once something's typed, it's there forever in the world of emails. And that's what I'm going on, that it may still exist.
Who would you be asking Mr. Dornfried to make contact with?
Your Honor, I believe that the police department has a custodian of records or or their tech department. And the same with the SBI, and I believe the request could be made of either to search, to see if there are any such documents in their systems.
What information from the SBI are you asking Mr. Dornfried to turn over?
Well, if Your Honor recalls, one major point of contention in this case was Mr. Deaver's testimony, and further as set forth in our motion relative to the handling and storage of evidence, and ultimately the motion to dismiss, there are certain, I'm jumping ahead to later, but there are certain pieces of evidence that were not tested for DNA to see whose DNA would be on it. Most specifically, the evidence of the clothing that was on Kathleen Peterson at the time she was found dead. And it was specifically not tested for DNA. There was an original request, I believe, from Durham Police Department when they forwarded those items to the SBI, but an Agent Barker crossed it out, initialed and dated it, and said, crossed out the request for DNA. So some of these items specifically that we saw here in court today have not been tested for DNA. And while obviously we're arguing because they haven't been tested, they now can't be tested, the other question is there evidence that shows that there was a reason for that, for selecting which items would be tested or not tested? And to the extent that my client's relationship with the police department was contentious, was there anything off the cuff even that said, if he jaywalks, we're arresting him? You know, whatever we get on Mike Peterson, we are going to charge him. To show the bias that swayed the investigation, that affected the investigation in such a manner that there was no pursuit of all the evidence to see for sure what happened. And that is our position. It hasn't happened. We're looking to see if there's anything documenting an inappropriate bias against my client.
Now, I would note that the defense has all of the notes, the handwritten notes of the prosecutors. If there's any even the slightest scintilla of inclination that was occurring, that would be referenced. But there is no such notice regarding any such evidence anywhere within the open file or the notes. And so therefore, Your Honor, that's what we're looking at here is throwing out a wide cast net in a broad fishing expedition when the defense has already had open file discovery and access to the minds of the prosecutors up until and through the trial itself.
I'm wondering if you're going to find anything in reference to Mr. Deaver with the SBI. You know, they kind of parted ways. I think both sides are probably cleaned up behind each other. I mean, who do you think in the SBI is keeping Mr. Deaver's files? that they hadn't already revealed, or information that he may have had, or information that other people have worked with him. You know, I've tried to get that kind of information in other cases that didn't have anything to do with Mr. Peterson's case. And several courts said I couldn't get that kind of information. So I'm not believing that this kind of stuff, if it ever existed, exists today. But I'm listening, Mr. Dornford, you know, I watch television every day. I watch a commercial now where one party is claiming Roy Cooper messed up. Do I need to say what the commercial said? I think you've probably seen it.
Actually, Judge, no. My coworkers give me grief, but I don't watch television. I haven't watched, you know, the only Olympics I've seen is news clips, but otherwise, I don't watch TV.
Not a bad idea, Mr. Dornford. But McCrory and Cooper don't agree with certain testing that was done in SBI labs. And I just got a sneaky suspicion we might not ever find out a whole lot about that. So I don't know that you're going to be able to find these emails if they ever existed from the SBI or the police chief. I mean, how many police chiefs have we had since then, Mr. Dornford?
We are, if we're counting interims, Your Honor, we can, I think we're on 1, 2, 3. I think we're on 4 permanent ones.
Yeah, I was here the whole time. I'm not sure you were, but
I was just barely here, yes, sir.
I mean, I swore Chambers in. It was a long time ago. I'm not feeling this is the kind of information that you're going to be successful finding. That's the real issue I have about it. I'm not saying it's not important or any of that. I don't think you can find it.
Are you denying the motion, Your Honor?
I'm denying it because I don't think that kind of information exists.
And for the record, Your Honor, we note our objection.
Which one would you like to address next?
Oh, I'm sorry. The next motion, Your Honor, was to compel discovery related to any and all individuals or agencies who accessed any evidence after the trial in State versus Michael Ivor Peterson. So we're trying to find the names, contact information, anything we can find regarding who may have had contact with the evidence in this case since the trial, especially because of the situation regarding its current condition to further pursue that. And to some degree, we've gotten some responses because we asked the clerks about log books, log sheets, date books, reports. We know that the clerk of court did not maintain them. We don't know if perhaps the SBI or Durham Police Department might have maintained their own records of going to view the evidence. And we would like any information that of people, relative to people who have gone not just to this evidence, but to other evidence to view it and to pursue or investigate what contact there's been, what type of contact with the evidence, how it was stored. Again, there's the issue of evidence from another case being found in with the Michael Peterson evidence, and we're just trying to determine who may have touched those bags beyond the clerk's office and those in court during the trial.
All right, and this request is described as what? This is a discovery request?
Yes, sir. It's a discovery request.
Mr. Dornfrey?
Your Honor, there have been two motions filed dealing with essentially the same type of request, but from different organizations. And one, we have the motion dealing with the clerk's office, which I think necessitated the need to have this hearing. Another one deals with the DA's office, the police department, and law enforcement agencies. And Your Honor, if I may address first the motion regarding requests from the Durham Police Department, the state, North Carolina State Bureau of Investigation, and the Office of the District Attorney. We're going to lose our lights. There are, within that motion, Your Honor, there are 4 requests. First deals with the names and contact information, and then goes through the different agencies of any employees of those agencies who were assigned to perform any tasks related to State of North Carolina versus Michael Iverson Peterson after the trial in 2003. The way that is worded, Your Honor, that would include anyone who was asked to make photocopies of the open file when we're dealing with the MAR, the people who are requested to then scan in different information, anyone who was asked to contact any of the relatives. That is not what is covered by Brady or 158903, and I would contend as well it was not covered under the motion for appropriate relief and the discovery standards as it relates to that statute. So as it relates to any tasks and the way that paragraph has been written out, it's so broad and covers such a multitude of individuals related to activities that have absolutely nothing to do with access to the evidence. Your Honor, I would ask that you deny the request as it relates to paragraph number 1. As it relates to paragraph number 2, it says the names and contact information of any and all law enforcement officers from the Durham Police Department, agents of North Carolina State Bureau of Investigation, prosecutors, employees of those agencies who obtained access to or handled in any manner any of the physical evidence introduced in the trial or any time after the trial. Your Honor, I do know that as a result of circumstances beyond anyone's control here, I was dealing with Mr. Clinkerson. Ms. Clinkerson is not in a position to join us here today, and I was talking to counsel about items that we've already sent over, and I know sometimes things end up in my file that my co-counsel may not be aware of, but the state has provided, and if council is unable to locate where those items may have been, we're willing to reissue these because we scanned them in and they're electronic, they're digital form. But there, from the police department, there is the property cards that detail the chain of custody. There also is logs indicating who pulled out or who had custody of these items as they're being shown to different individuals. Within the property itself, at the Durham Police Department and the forensic unit, or rather the police department, if there's items being opened up, they note on the bags themselves who it is that they're opening up for. So all this information would be contained, would have already been provided. Your Honor, we went further in contacting the Court of Appeals and obtaining information from the Court of Appeals and providing that detailed from whom items were returned to or from whom they were received from, and they indicated the items that the exhibits they had in their custody. And so, Your Honor, I would contend to the court that as relates to the Durham Police Department, as far as the safe road investigation, there's no further evidence has gone to that location. As far as the prosecutors, Your Honor, I would contend other than individuals who either assisted in the transport or picking up of exhibits at the Court of Appeals, anything else we're dealing with being accompanied by either a clerk, if that occurred, or with the forensic unit or the property tech at the police department. So, Your Honor, I would ask the court not to compel as it relates to information regarding prosecutors or their employees, as that would then go to give information about what is that we're interested in. One is it's available if they want to go look at the actual evidence at the Durham Police Department. Otherwise, if it's from the clerk's office, it does not appear that there's been any notations regarding who may have seen these items. But what has been set forth is that they were accompanied, whenever these items were shown, they were accompanied by a clerk, that the clerk ensured that individuals were wearing gloves, and therefore, Your Honor, as far as any prosecutor, if you find out what someone's looking at, you can figure out what they're thinking. And therefore, Your Honor, as it relates to the prosecutors, I would ask that you not grant that request as it relates to the police department and law enforcement agencies. I would contend that would fall underneath information dealing with the investigative file, and therefore should be turned over, and we would contend have been turned over. Any log books, log sheets, date books, reports, and any other recordation of any law enforcement officers, Durham Police Department, agents of the State Crime Lab, and then the prosecutors who relate to any employees of those agencies who obtained access. The same argument, Your Honor, goes certainly as it relates to the State Crime Lab and Durham Police Department. I would contend that they have a right to see that as part of the investigative file, and we have turned that over. As it relates to the DA's office, Your Honor, I would contend that is not the case and should be denied as it relates to the District Attorney's Office. And then lastly, in the last paragraph, identifying information concerning any and all locations where any and all the evidence in State versus Michael Ivor Peterson has been stored since Mr. Peterson's trial in 2003. Your Honor, when we look at what's been provided by the Court of Appeals, as well as with the forensic unit and the property unit with the Durham Police Department, all that has been turned over already, and if need be, we can reissue that discovery. As it relates to the clerk's office, obviously certain items are in their custody, and Your Honor, the state is not in a position to create something that is not already in existence and fell under the control of the agency outside of the control of the District Attorney's Office. We've heard testimony here today from the supervisors as well as the elected clerk of court that would answer, or at least answer as best as could be answered, the questions as it relates to the location of the Peterson evidence. And therefore, Your Honor, I would ask that then as far as that paragraph, it'd be denied because it seems as though there may be some question regarding some of the Peterson evidence while in the custody of the clerk's office, and we've had an evidentiary hearing to try to get to the bottom of that, and the answers are as they came forth during this hearing. Your Honor, that I believe that addresses the 4 requests regarding discovery from law enforcement agencies and the district attorney's office.
Well, Mr. Darrell, he's saying basically through his open file, discovery, and other requests that he's giving you pretty much what he thinks you're entitled to.
I understand that, Your Honor. I believe, in truth, that I will agree with Mr. Dornfried that the 4th item has, by virtue of the hearing today, that has been satisfied. However, what we have learned today is that there are no log books or log sheets or anything to that effect that shows who has had access to the evidence in the trial since the trial. And that's what we were asking for, is the evidence since the close of the trial, to try to find out who may have had access to this evidence in addition to the clerk of court who handled it. And in that, we don't have that information available from the clerk of court. If law enforcement or any other, or the district attorney's office had occasion to come and look at, for example, box number 7. Who was it? When? Did they wear gloves? What occurred and who was there? It'll allow us also to track back and try to determine at what point these items became contaminated, such as, is this literally the way they were packaged and it's just been that way since October 2003, or has something happened to the evidence between 2003 and this day in 2016? We're just trying to be thorough, to look at all possibilities and ensure that we know as much as we possibly can about the exhibits that were placed in evidence during the trial.
You have a way of knowing when an assistant DA went to the clerk's office to look at a...
Your Honor, we provided information. We did speak to Mr. Sachs. He gave information that was provided to defense counsel, and I believe was reiterated in the testimony.
Who other than David Sachs would have been over there other than Jim Harden?
Actually, Mr. Harden did not. We did speak with him, and we got a statement from him and provided that to
I
counsel.
didn't say he did. I just said other than...
Well, Your Honor, I
Sachs
believe
and
that I believe in passing, I did speak to Mr. Eccles. I need to get a more detailed information from him that he assisted after the motion for appropriate relief, and the company of Susan Lanning went with her as she delivered items to the Court of Appeals. As far as the items, interestingly, the items from the Court of Appeals is not really a matter as far as what is at issue here today, because all those items were returned to the police department, and you've heard testimony about the condition of all the items at the police department were not the same as the items that are here in court today. Otherwise, Your Honor, what I'd be looking at is trying to talk to everyone who's been in the DA's office since the trial, and some have left. There's some I haven't spoken to. Some I've tried to speak to for other reasons and have been unable to make contact. But that's, in speaking with Angie Kelly, I was asking these questions, and I didn't, other than Art Holland, that's why I brought that out, was she remembered Art Holland, but otherwise, as far as DAs, I'm not getting other information of other individuals. I haven't spoken to those particular DAs who have moved on, and the question is just trying to make contact with them. And I have no reason to believe that they did, but nonetheless, they're no longer with the DA's office, and sometimes it's difficult to get in touch with people who have moved on.
And when you leave, Mr. Dornfried, I bet they won't be able to find you either in all the cases that you worked on in your, I don't know how many years. But you're not gonna leave.
Well, it'll be a long time, Judge.
Yeah,
I'm hoping.
I understand. I'm just not seeing that as a practical matter. Very many of these requests are gonna get very far. I just don't believe that the police were logging in if they went and looked at evidence separately from what the clerk had.
As far as with the police department, Your Honor, the items in their custody, they did keep track of that as far as if they were being pulled to show to individuals, and that has been provided to defense counsel or to defense already. If
Yeah.
that's what you're making reference to.
I mean, other than that, I
Oh.
don't think that,
No, sir, otherwise it would be items, I believe, that are in the possession of the clerk, and we've heard testimony today regarding that.
So I believe, Mr. Dornfried, if I understand you correctly, you're saying that the police department and other law enforcement agencies don't keep logs of when they go to another agency to look at evidence. They don't document that. They document when they look at their own evidence. Is that what you're saying?
If an officer is investigating something, then that would be part of their investigative file. And speaking with, in this case, Your Honor, the only investigator that I'm aware of that was working as a lead detective was Art Holland, who I did speak with and asked him specifically, did you have any contact with this evidence in any manner, shape, or form after the trial? And that has been documented via a conversation that was memorialized and provided to defense counsel. Other than that, I've never heard of, when we're talking about logs, about evidence that's in their custody and they're keeping track of who has access of it and the chain of custody, and that has been provided.
And so therefore, they don't keep logs of when they go elsewhere to look at custody, because it's not, to look at evidence because it's not in their custody. In other words, if there are no logs, we're asking about the evidence introduced at trial in the trial of State v. Michael Peterson. In other words, if there are no logs maintained by the clerk of court as to who accessed this evidence, then there is no documentation. There are no logs that establish who had contact with these pieces of evidence, correct? Is that what you're saying?
That would be my understanding, Your Honor, speaking with law enforcement.
Thank you.
that's probably right. Yeah.
I believe it probably is, Your Honor.
All right, what else we got?
Well, Your Honor, as it relates to that motion, the one we haven't dealt with is the first one that was addressed, which was performing any tasks. And I made my argument regarding that. I think it's overly broad, does and falls outside the scope of discovery. That would encompass most of the support staff in our office, because the evidence in this case, as I'm sure the court is aware, is quite voluminous, and it required a significant amount of individuals in order to assist in providing discovery. But that's dealing with items that have been turned over. It's not dealing with the evidence itself, whether it be at the police department or at the clerk's office. And therefore, Your Honor, I would contend that, number one, dealing with any task should be denied, as what it sounds like what defense is really interested in is who had access to this physical evidence, and that's addressed in the subsequent paragraphs.
And I guess I would respond by just asking, has the state represented that but for taking evidence from the clerk of court's office to the Court of Appeals, the district attorney's office has not performed any tasks on the evidence introduced at trial?
There was also retrieval, I believe, pursuant to the rules of appellate procedures. One of the parties, not the clerk of court, has to retrieve the evidence, and that is documented and has been provided to you.
Correct, the retrieval from the Court of Appeals.
To the police department, yes.
Right, but other than as required to select the evidence, take it to the Court of Appeals on 2 occasions.
Yes.
And retrieve it, there have been no other tasks performed by the district attorney's office in relation to the evidence in custody of the clerk of court.
Well, that would go to individuals who may have left. I don't know if they went and saw it, Your Honor. There was a prosecutor who was assigned before. I don't believe that she looked at it because in my discussions with her, it never came up. But as far as tasks, I would just renew my same response, Your Honor, that I can't say whether or not somebody went to look at something, but if they did, they were accompanied by a clerk, and we heard from the clerks. But in my question of multiple clerks, and we provide, even retired clerks, and we provided the information of Tracy Lutz and Susan Lanning to the defense, there's no other indications of prosecutors having access to any of the evidence within the clerk's office other than the assisting in either transportation or picking up of evidence at the Court of Appeals, as well as viewing it in the presence of present counsel.
Okay. And then, Your Honor, I would just ask that if Mr. Dornfried at any point in time learns otherwise, that the district, or anybody at the district attorney's office learns otherwise, that we be so informed.
That's fine, Your Honor.
All right. Did the Supreme Court not review any of the evidence? You keep talking about the Court of Appeals, but I know the case was also heard by the Supreme Court.
It did, Your Honor, and within...
They may not have looked at the
I don't know if they
evidence.
looked at, I know that from the documents that I saw from the clerk of court for the Court of Appeals, they referenced what exhibits had been delivered to them. I can't say what happened once they got to the Court of Appeals as far as to the Supreme Court. They just provided us with information regarding what they took into their custody and then what was then returned. Which, to my understanding, they no longer have any evidence as relates to this case.
Yeah, I don't think they would have had to have the evidence to do what they did with the Court of Appeals decision. They didn't need to view it.
Yes, sir. And then I guess the final motion deals with the hearing that we had here today. And the testimony speaks for itself regarding the logs and the condition and the other questions posed within that motion. Your Honor, that's an agency that the state is an independent agency that the district attorney's office, they are a neutral agency. They work with both defense and the state. Unlike law enforcement, in which we work in conjunction, they are separate, and for which the district attorney's office has no control over, and they've given the answers regarding the questions posed by both counsels.
Yes.
Your Honor, the only other thing, I would agree with Mr. Dornfried on that. The only other thing I would like to raise before the court, with the court's indulgence, are the conditions of pretrial release for my client. And at this point, we would ask the court to release him from any further reporting requirements. He has been fully compliant. I have a report from Miss Christy Long, who is his supervising pretrial services officer.
Okay, well, let's hold on before we go there. So, where are we going now with what's left to be done? Something is going to be done in November.
We hope so, Your Honor.
What?
Unless you want to do it today, and we are more than happy to urge you to grant our motion today.
Well, I'm just wondering what's left.
Your Honor, the discovery motions have been heard during our pre-hearing scheduling conference. We had agreed, it was my understanding that we would hear these motions, and then in November, would hear the, specifically, the week of November 14th to address the motion to dismiss that defense counsel has filed based on the condition of based on the evidence within the custody of the clerk's office. The state had made its argument known at that time, and I believe all parties were in agreement that we would hear the motion on November 14th.
Well, is there going to be another opportunity for the presentation of expert?
I'm hoping so, Your Honor. I mean, that has been my plan, which was in that the motion presented to the court today, and as I understood, would only address what is the condition of the evidence, that in November, because of the motion dismissed, we would supplement what has already been written and presented to the court with expert testimony to the extent that with the cross-contamination, that the materials, the items in evidence that we would like to have tested cannot be tested under any circumstances, not legitimately tested with a legitimate expert opinion.
Right, I know I've met with counsel about some other dates, so what's supposed to happen on the 14th?
You know, I believe both sides are going to be presenting evidence, and I don't know how long it will take. I'm hoping it won't take all week. I don't think it would. But both sides will be presenting, I'm sure the state will be presenting some evidence. It sounds like the defense counsel has evidence, and then we can be heard on the motion.
But you don't know now what her evidence is going to be, or you do?
I'm going to discuss it with her, but I believe defense counsel did give me a copy of the email. That gave me some insight. I do not have a full report from their expert, and looking over the discovery, Your Honor, if the state requests it prior to trial, the court shall order that the defense turn over the expert, but we're not dealing with a trial. However, in this circumstance, Your Honor, what they're asking for is for no trial, for dismissal. And Your Honor, we would ask that the court order that if they are going to use an expert witness, that a copy of that report be provided in a reasonable time prior to the hearing, and the state would reciprocate regarding any expert witnesses, should the court grant that that request.
And I dare say the report has already been presented to
Okay, that is the report?
the state. That is the report that
Okay.
we have. It addresses the condition of the exhibits presented at court today and addressed by Mr. Kendrick in his testimony. If the state wishes, we can find additional experts to come in with similar testimony and take longer, but I don't know how many witnesses we need to establish the same point, Your Honor.
I don't know, you have the burden of proof, that's what you told me earlier today.
I believe we can meet it without having a herd of witnesses or a horde, whichever it may be.
Okay, so it looks like y'all know what's going to happen in November.
I think so, Your Honor. The state has impression. We have an open line of communication, and I think we have good communication between both parties as far as what to expect in the upcoming hearing.
All right, you were talking about pretrial release?
Pretrial release, Your Honor. My client still has to report in to a pretrial services officer, which is Christy Long. She has provided us with a report, and there have been absolutely no violations whatsoever. And so we would request that all of the special conditions be removed. Would you like me to tell you what they are?
Yeah, I don't remember all of them.
You are going to remove them?
I said I don't remember all of them.
Okay,
Yes.
I'm sorry. Okay, 1, maintaining weekly contact by telephone check-in as scheduled. 2, reporting to office for scheduled appointments or home visits. 3, maintaining a stable residence or notify pretrial of any change of address. Notify pretrial if there's any change in attorney. Report for all court appearances, and refrain from obtaining additional charges. He is compliant with all of those. The other ones listed in her report are not applicable according to Ms. Long. Those include maintain employment or notify pretrial of any changes in employment, refrain from the use of illegal drugs while under supervision, submit to a random drug screen as requested, compliant with curfew, electronic home monitoring, and going to school regularly with no excessive tardiness or absences. And she has designated those items as being not applicable to Mr. Peterson's situation.
Wasn't there a condition at one point about not going to Northern Virginia or something of that nature? Did I strike that at some other point?
The only, that is not there, it's in her, it's separate from those. Whenever he has traveled through Northern Virginia, he has had to so notify pretrial services. It's my understanding that is being done so they can notify his former sister-in-laws that he will be in the area.
Right. So that is a part of it.
It is, I'm sorry, it was in the comment section, and he has,
So you thought I forgot?
you're better than I am, Your Honor.
I didn't forget.
That's why you're the judge.
Yeah. Go ahead. What about it? I said, were you asking to change that?
Well, we'd like to have everything removed, but if you would like him to continue to so notify the pretrial service officer, I'm sure he wouldn't mind letting her know when he's traveling through Northern Virginia.
Yeah, my understanding was that they were terrified of Mr. Peterson.
That's
That's
what
they-
I have been told.
That's what they said, yeah.
That's what I've been told. There has been no contact with them since 2003 or before. So, I think he's had ample time, if he were so dangerous as to attack them. We would have uncovered it by now. I think he's safe, Your Honor.
Well, I don't know when that was. I've only been to like 1,000 counties and tried 1,000 cases since then, but when was that? When was that order?
July 2014, July 8th, 2014. So it's been over 2 years now.
Yeah, seemed like yesterday, actually. So how would he notify someone without pretrial services? Or you just think it's not necessary?
I personally, Your Honor, do not believe it's necessary, but so long as Ms. Long was his supervisor or supervising pretrial officer, I believe it could just be made a special condition of his release that at any point in time he travels through Northern Virginia, that she be notified. But as far as calling in, home visits, if If he does not show up for court, I dare say everybody in the eastern part of North Carolina will know if he fails to appear.
Mr. Peterson is going to show up for court. I'm not concerned about him showing up for court.
Right. And that's one of those conditions that I don't think we need. Refrain from obtaining additional charges. If he obtains additional charges, the system is in place to further prosecute him if appropriate.
I'm only concerned about the residents in Northern Virginia. They were very concerned about Mr. Peterson.
None of these conditions, none of these standard conditions have anything to do with the residents in Northern Virginia.
Yeah, I understand.
Okay. So I believe that there would be, if their comfort level is still very tenuous, then we, I believe, would certainly be welcome to advising Ms. Long or whoever else is designated that he will be traveling through.
Your Honor, when we look at what is he presently dealing with, obviously the state was concerned primarily with notification to Ms. Long, who then notified the relatives about travel through Northern Virginia, and we would ask that that continue. When we look at the other conditions, well, one is don't pick up other charges. That's basically what we have on everyone who makes bond. You don't expect them. Now, whether or not that happens is a different issue, but saying don't pick up charges, that should stay in effect. Come to court, that should stay in effect. Notify pretrial of a change of attorney. Well, Your Honor, I'm not asking for that. I think we're going to know if something happens regarding his counsel. So what we're left with is making a phone call once a week and being subject to scheduled appointments or home visits. And based upon the charges, Your Honor, the state does not consider that to be an onerous burden upon the defendant based on the charges that he's facing. So therefore, Your Honor, we would ask that making this call weekly and being available for a scheduled appointment not be redacted from the terms of his condition. If we're going to have the notification regarding travel, then under those circumstances, he would still be on a pretrial because we would need Ms. Long's cooperation in order to let the family know. Therefore, Your Honor, we would object.
I think that I only want Ms. Long involved with Mr. Peterson to make that phone call.
When we talk about that phone call, talk about the travel, Your Honor?
Yes.
Okay.
I don't think Mr. Peterson is going to fail to appear. I think he's smart enough not to commit a crime. And you keep adding people to the prosecutor's staff to this case, Mr. Dornfrey. You keep losing assistants. So if you all don't hurry up and have a hearing to dismiss or a jury trial, you're gonna run out of assistance. You're gonna have to handle it yourself.
Well, Judge, I think,
Ms. Gallagher's here now, but I mean, she's such a smart attorney. If you keep putting pressure on her, she'll leave,
well, I think from the.
like your last assistant left.
Actually, Judge, that was lead counsel, I was number 3, and I kind of got moved up. So,
I felt like you were running things behind the scenes. I understand she was designated as lead counsel. But
no, sir. But things change, and we'll be prepared.
I don't think Ms. Dara is leaving.
No, sir. I hope not.
So what are y'all gonna do if Mr. Peterson's case comes to an end? Hadn't thought about it, huh? No one's thought about it, really?
For me, Your Honor, I move on to the next case.
All right, what else we got?
I believe this concludes the business before the court for today, Your Honor. I cannot speak as tomorrow, Judge. I've been here, so if you like, I can find out. I don't think we had scheduled anything for you.
That's a good idea.
Okay.
May I clarify, Your Honor, are you maintaining the conditions that are currently in place, or are you removing some?
One condition,
One condition. Very well. Thank you, Your Honor.
and you know what that is.
I understand.
Very well. Thank you.
All right, y'all are tired of talking now? I mean, you can continue.
I'm done, Your Honor.
You still got the cameras and everybody here. They're still here past 5:30. They're still here. Okay, I guess we're finished, Mr. Deputy. We'll say 9:30, even though I don't think I have anything.
Thank you, Your Honor. Court's in recess till 9:30 tomorrow morning. Where's that? I didn't tell.
Just tell Remy to turn it off.
It sounds to me like
You want to do your special? You want to do something?
Yeah, no, I think yeah, so, November.
Let me grab it. You need to be back. You need to be back.
What you need help with?
It's the one that Mr. Dornfrey said he didn't have anything.
I've got them, I was going to put them back in order. Because I have a feeling that the way I picked them up, that I made a big mess. I kind of threw them out. They weren't.